Hello everyone, I am Shashank and welcome back to my channel. So guys, in this video, we are going to discuss Article 15, which is Protection Against Discrimination and Social Justice. Article 15 says, there shall be no discrimination on grounds of religion, race, caste, etc. Article 15 Clause 1 specifically bars the state from discriminating against any citizen of India on grounds only of religion, race, caste, sex, place of birth, or any of them. Article 15 Clause 2 prohibits subjection of a citizen to any disability, liability, restriction, or condition on grounds only on religion, race, caste, sex, or place of birth with regards to access to shops, public restaurants, hotels, and places of entertainment, or the use of wells, tanks, bathing ghats, roads, and places of public resort. Article 15 Clause 3 provides that nothing in Article 15 shall prevent the state from making any special provision for women and children. The clause is one of the two exceptions to the general rule laid down in the clauses 1 and 2 of Article 15. The physical structure of women and children is the basic reason in this regard. Children need special care and protection. They are the country's future. Hope of future rests on them. Now let's take a case here, which is Miller versus Oregon. The American court held that woman's physical structure and the performance of the mental functions place her at a disadvantage in the struggle for subsistence, and her physical well-being becomes an object of public interest and care in order to preserve the strength and vigor of the race. In Article 42 of the Constitution provides that the state shall make provisions for securing just and human conditions for work and for maternity relief. The provision of Article 42 is not violative of Article 15 Clause 1. Let's take some examples of cases. In Datatray versus State, Bombay High Court says that state can establish educational institutes for women only if educational institutions are established by the state exclusively for women. The reservation of seats for women in a college does not offend against Article 15 Clause 1. Another case, in Yusuf Abdul Aziz versus State of Bombay, the Supreme Court held that Section 497 of Indian Penal Code, which only punishes men for adultery and exempts the woman from punishment, even though she may be equally guilty as an abettor, was held to be valid since the classification was not based on the ground of sex alone. It is generally accepted that it is the man who is seducer and not the woman. The provisions of Section 125 to 128 of CRPC 1973 had been provided for a wife, divorced or not, to claim maintenance from her husband or from other relatives. In Noor Sabah Khatun versus Muhammad Qasim, the Apex Court held that the purpose of these provisions was to provide the immediate means of subsistence to the applicant before she withered away by hard way of life and realities for lack of minimum means which were applicable to all applicants, irrespective of the community, caste, or creed. Article 15 Clause 4 provides that nothing in Article 15 or in Clause 2 of Article 24 shall prevent the state from making any special provision for the advancement of any socially, educationally backward classes of citizens or for the scheduled caste and the scheduled tribes. Article 15 Clause 5 provides that nothing in this circle or in subclauses of Clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially, educationally backward classes of citizens or for the scheduled classes or scheduled tribes, insofar such special provisions relate to their admission to educational institution, including private educational institution, whether aided or unaided by the state, other than the minority educational institution. Now let's talk about personal law. In family matters, there are different personal laws. That is Hindu law for the Hindus, Muslim law for Muslims, and so on, unless these laws have been amended by statutes. Some of them, like Muslim law, have been left unamended. Challenges to these laws on the basis of religious differentiation or on the basis of differentiation between males and females have not been generally accepted. In T. Saritha versus T. Venkata Subhaiya, the court declared Section 9 of Hindu Marriage Act, which provides for the restitution of conjugal right as invalid on the ground that in practice it works against the females and not against the males. The court held that sexual cohabitation is an inseparable ingredient of a decree of restitution of conjugal rights To have sex with an unwilling party against her will offends the inviolability of the mind and body. Section 9 of Hindu Marriage Act infringes Article 14 for two reasons. First, Section 9 does not satisfy classification test, although on its face Section 9 makes the remedy of the restitution of conjugal right available to both husband and wife. Yet in practice, it is almost exclusively invoked by the husband against his wife, so the remedy becomes partial and one-sided. Secondly, Section 9 fails to pass the test of minimum rationality required by any state law. It subserves no social good and promotes no legitimate public purpose. On the other hand, in Harbinder Kaur versus Harmandir Singh, the Delhi High Court upheld the constitutional validity of Section 9 of Hindu Marriage Act. The court said the restitution aims at cohabitation and consortium and not merely at sexual intercourse. The Supreme Court in Saroj Rainey versus Sudarshan Kumar, agreeing with the Delhi High Court, held the provision in Section 9 valid. The court has emphasized that one must see the degree of restitution of conjugal rights in its proper perspective. In India, conjugal right, that is the right of husband or wife to the society of the other, is not merely a creation of the statute, but it is inherent in the very institution of marriage itself. There are sufficient safeguards in Section 9 to prevent it from becoming tyrannical. Section 9 is only a codification of the pre-existing law. Only when the decree is disobeyed willfully, the court may order attachment of property. It serves as a social purpose, as an aid to prevent the breakup of marriage. The purpose of Section 9 is to save the breaking of home. Now the most important topic in the Article 15, which is the special provisions for advancement of backward classes. Article 15 Clause 1 would have come in the way of making special provisions for backward section of the society. An order of Madras government allotting seats in the state medical colleges community-wise was declared bad because it is classifies students merely on the basis of caste and religion, irrespective of their merit. Similarly, in Jaswant Kaur versus Bombay, a government order requisitioning land for construction of a colony for Harijans was held to be discriminatory under Article 15 Clause 1 because the facilities were given as a community. As such, when the other members of the public were equally in need of similar facility. To tide over the difficulties created by these decisions in the way of helping backward classes by making discriminatory provisions in their favor, Article 15 Clause 4 was added to the Constitution in 1951 by Constitution First Amendment Act 1951. Article 15(4) says that state is not prevented from making any special provision for the advancement of any socially and educationally backward classes of citizens or for scheduled caste and scheduled tribe. A major difficulty raised by Article 15 Clause 4 is regarding the determination of fact who are socially and educationally backward classes. This is not a simple matter as sociological and economical consideration come in play in evolving proper criteria for its determination. Article 15 Clause 4 lays down no criteria to designate backward classes. It leaves the matter to the state to specify backward classes, but the question is whether the criteria used by state for the purpose are relevant or not. In Balaji versus State of Mysore, it was held by the Supreme Court that a classification between backward and more backward is not bad. The view has been upheld by the Supreme Court in Mandal Commission case. K.S. Jayashri versus Kerala, a government order excluding the candidate belonging to socially and educationally backward class from claiming the benefit of reservation if the family income was Rs 10,000 or more was upheld as valid. The court emphasized that the social backwardness is the result of caste and poverty. Both factors are relevant. Caste cannot be the sole or dominant test for the purpose. Caste and poverty are both relevant for determining the backwardness, but neither the caste alone will be the determining test. Reservation and admissions. Regarding reservation of seats for admission for certain categories of persons other than those falling under Article 15 Clause 4, the main question to be considered is whether the classification is reasonable. The quality principle is not infringed if reservation is made for a class which is based on an intelligible differentia. The Supreme Court is of the view that the socially and educationally backward can be shown same preferential treatment because of Article 15 Clause 4. The idea is that in course of time these persons will be able to stand in the equal position with more advanced sections of society. The same principle may be applied to the handicapped sections which do not fall under Article 15 Clause 4. In Sunil Jaitley vs. State of Haryana, it was held that reservations of seat for admission to MBBS/BDS course for students who received education from class 1 to 8 in common rural schools in preference to students educated in urban schools was held to be violative of Article 15 Clause 4, as the classification between rural and urban educated students was wholly irrational and arbitrary. In Dr. Nilema vs. Dean of PG Studies AP, Agriculture University, Hyderabad, the Supreme Court held that if a high caste girl marries a scheduled tribe boy, she shall not be entitled to reservation benefit. In Dr. Preeti Srivastava vs. State of Madhya Pradesh, the Supreme Court held that merit alone can be the criteria for selecting students to the super specialty courses in medical and engineering streams. At the level of admission to the super specialty courses, no special provisions are permissible. So guys, Article 15 is complete. I hope you like this video. Please make sure to subscribe and press the bell icon. And also share and like this video. My next video will be on Article 16. Till then, be happy, be healthy and stay focused. Thanks for watching.